Here are 7 things that you should not include in your will. And trust me, I have seen some things that should not be in a will.
I've seen some things.
When you have a will, when it gets probated, that becomes public record. So that alone should be reason enough to think carefully about what you're going to put in your will, because even though you won't be here anymore, your loved ones will be, and that information could be seen by anyone who wants to see it at the clerk's office. So first thing not to include in your will, anything that's controlled by a beneficiary designation. So think life insurance, annuities, IRA, 401k, anything where when you set up the paperwork, you're told, okay, who do you want to be your first beneficiary? Who's your backup beneficiary? That's because those beneficiary designations control. And it doesn't matter what you write in your will, if there is a beneficiary designation on a life insurance policy, and for example, my life insurance going to my husband, if for some reason I wrote in my will that it would go to Britney Spears.
What?
It doesn't matter. My life insurance designation says it's going to my husband. Sorry, Britney Spears, you're not getting my life insurance, so you probably don't need it anyway.
You would never do your life insurance to Britney Spears. It would be
If it's Taylor Swift, she also doesn't need it. Yeah, don't put that in your will, but also make sure you're reviewing those regularly so that you can keep your beneficiary designations up to date. I know a lot of people that come in to see us that maybe they got a life insurance policy before they met their spouse, and they've got, a parent or an extended family member listed as a beneficiary, and they don't even realize it until they go to do their estate planning documents, and they think, oh, well, I updated my will, so I'm good. Imagine the surprise when your spouse is like, oh, your Uncle Johnny is getting the life insurance because you set that up before you ever met me. So make sure you're reviewing those designations regularly. Next thing not to put in your will, assets that are held by a trust. A trust is a way to avoid probate altogether, provided that it owns the things that you own. So if you have a trust and it owns your primary residence, well, the terms of that trust control what happens to that residence, or anything else that's owned by the trust. So if you have a will, which you should have a pour-over will, you should have a backup will if you have a trust, just in case your trust doesn't own everything that you own, then whatever you say in the will doesn't control because that's owned by the trust. So similar to your beneficiary designations, that the trust ownership of that property is going to be what decides what happens with the property. And of course, you decide that when you create your trust instrument. Next thing, funeral arrangements shouldn't really go in a will. If you do, I guess it's not the end of the world. It's just that it might not be reviewed in advance of your funeral or whatever you decide you want for remembrance services. I guess in some families, they may try to locate a will before doing any services, but not always. In fact, I'd say it's more often than not that the will isn't located or read until after those services have been completed. So if you have something specific that you want, you'd want to find another way to communicate that. In our office, for a lot of our estate planning clients, we provide them, a remembrance and services memorandum that they keep independent of their estate plan documents. They kind of put it somewhere that they put important paperwork, but not necessarily behind lock and key, that says, hey, this is where I'd like my services to be held. I've already paid for, a burial plot, or I've already paid for a cremation, or whatever they've decided. Here's the receipts, here's who you call, etc. Just so that family members or whoever's taking care of those arrangements will have an idea of what to do. But if you put it in your will, that information may not be seen until after those services have already happened, so your desires wouldn't be taken into consideration. Similar to that, your end-of-life decisions and your healthcare decisions, will is not the place to put that information. Again, because your will becomes effective when you're no longer living. And if you need to talk about your health care, that's happening while you're still living. So you would need that information in a separate document. In North Carolina, we have healthcare powers of attorney where you can designate a person to stand in as your healthcare agent and give them as much or as little power over your healthcare decisions as you decide. The max basically being anything that you could decide about your healthcare, but you can also limit the healthcare agent's authority. But that would be the appropriate document to tell another person what what they're allowed to do or decisions they're allowed to make on your behalf if you're not able to make them. And then also in North Carolina, we have something called an advance directive, which is basically the instructions for a natural death. So if you don't want your life artificially prolonged under certain circumstances, this instrument can be used to let your healthcare providers know, hey, based on these situations that I've initialed or that I've described to you, don't use artificial means to prolong my life. The form that we use can be revoked, and it can be revoked verbally too. You know, if you're in the hospital, you can tell your doctor, hey, I no longer want you to go by that document. But of course, depending on where you live and what document you're using, make sure you review the terms of that carefully, because that may not be the case wherever you live or the instrument that you are using. Another healthcare thing is organ donation. So if you put that you want to be an organ donor in your will and the will's not read until after your services, well, any opportunity to be an organ donor has kind of, you're out of luck. That is something that in North Carolina you can put in a healthcare power of attorney, and you can state whether you do or don't want to be an organ donor. And if you do, whether it's for anything that's needed or if it's only for certain things. So if you feel strongly that you don't want a certain organ donated, or that only certain organs can be donated, you have an opportunity to clarify that. Same thing when it comes to donating your body for study. You get to decide whether you want to do it or not, and then if you do, whether it's only in certain circumstances. But that is not something that would go in your will. The next thing not to include in your will. This is not a mandate, but I would encourage you not to include kind of long, drawn-out emotional reasons for why you're doing what you're doing in your will. I've seen instances where it's just created animosity among the survivors. If you're saying, I'm going to give everything to my granddaughter Alyssa because she's the only one that ever visited me in the nursing home, or I'm not going to give anything to so-and-so because they're a good for nothing, or because they're an Ohio State fan, or whatever it may be. Those things tend to come up among the survivors and sow discord between them, and then create situations where maybe somebody wants to contest or says, oh, you've exercised some sort of undue influence because grandma would have never picked you and you only went to the nursing home so that you could get her to give you everything. So instead, when you're doing your beneficiary designations, or when you're talking in your will about who you're going to leave what, just keep it to the simple, straightforward, who gets what. There may be times where if you're disclaiming someone or saying you don't want to include them, that you need to include a statement to that effect so that they know they weren't forgotten and that it was intentional. And that's to prevent, challenges later, or, defend against challenges later. But that's something that you'll talk to your attorney about. In general, though, keeping the emotions limited in the will. And then finally, if you own property in an entity, so just like with a trust, like if you own property in an LLC or a corporation, the organizational documents of that company control what happens with that property. So you own an interest in the company, so you don't necessarily get to say what happens with the company's assets. You get to say what happens with your interest in the company. So yes, it's appropriate to talk about the disposition of your interest in any entities that you own. But if that entity owns a vacation house, then you don't necessarily get to say, I, Tiffany Weber, give the house at 123 Main Street that's owned by 123 Main Street LLC to my husband Ryan. Like it'd be more appropriate to say, I give my interest in that LLC to my husband Ryan. But those are things not to include in your will. There's a lot of really good things to include, but whenever it's time to go drafting your estate plan, keep these things in mind and make sure you're updating your beneficiary designation. Like, should I let people know that's my husband behind the camera? I'm not a doctor, so sure.